I'm Denver criminal defense attorney Michael Becker. It is very rare for the Colorado governor to agree to commute, which means to reduce a defendant's criminal sentence, but it's worth a try. In order to be eligible for a commutation, which is officially called executive clemency, the inmate must have served at least a third of his or her sentence, or 10 years, whichever is shorter. For inmates serving life sentences, they must have served a third of their time before being eligible for parole, or 10 years, whichever is shorter. And for inmates serving consecutive life sentences, they must have served at least 10 years. 5 of the factors that the governor considers when deciding whether to grant commutation include: 1. Whether the inmate has been rehabilitated. 2. Whether the inmate displayed acts of heroism to prevent injuries to other inmates or prison staff. 3. Whether the inmate has been sentenced more harshly than others convicted of the same offense. 4. Whether the inmate is terminally ill or suffering from a catastrophic condition. Or 5. What impact the inmate's crimes had on his or her victims, if any. But there are various factors that could disqualify defendants from getting a reduced sentence, even if they served enough time. For instance, commutation is unavailable to defendants within 15 months of their parole eligibility or those who have pending appeals for their conviction. And the governor may not reduce the sentence for treason or violent crimes against a police officer. If you're facing criminal charges, we invite you to contact the Colorado Legal Defense Group at 303-222-0330. My experienced legal team will fight to get your charges reduced or dismissed.